Okay, good afternoon, guys, and welcome to part of our leadership series. This is something separate to what we do in terms of the IMAA's Insights Innovation Series. This is about the business of running businesses, and we only put them on when there's something really important that you guys need to know about, which is privacy law, today and tomorrow. So we've got the great Stephen von Muenster, I love saying your name, Steve, who works with us. He is going to be running through a bunch of things. So firstly, an overview of the ACCC's digital platform inquiry, and also diving into the complexities of what is consumer data laws, everything that you guys need to know and everything that you guys need to prepare for what's coming around the corner. But without further ado, I'm going to hand over to Stephen and he'll run you through the presentation.
Rob, thank you, Sam, and to Becky as well, if she's around, for inviting me and allowing me to present this presentation today on privacy law today and tomorrow. Ladies and gentlemen, I'd just like to say a quick happy new year to everybody, and hoping that 2022 is a little bit more predictable and certain than the last couple of years. Of course, as we will see during this COVID pandemic, businesses have benefited greatly from digital platforms and the ability for us to remain connected as we are now during times of lockdown. Privacy law today and tomorrow is just exactly what I mean. It's about talking about where the privacy laws are now, and there's a lot happening in the privacy law space under existing laws, as you will see, and then where it might go tomorrow, and that's the focus of this. And as we will see, I have some predictions at the end. So remaining on this current slide, look, just by way of an introduction, digital arrived quite, I suppose, gently some 20 odd years ago to where it is today. And there's been some significant benefits that digital technologies have brought. It's brought us all closer together, and it's allowed us to remain connected during the COVID pandemic, and continues to allow us to deliver content like this presentation in a very easy way, without all having to turn up at a venue somewhere like we always used to do just a couple of years ago. Obviously, digital is all about enabling efficient and effective advertising connection with consumers in an creepingly increasingly accurate way. As we speak during the night and we speak to our phones, and suddenly we get served ads in the context of what we're speaking about. That's what this is all about, this presentation. Of course, there is a dark side that has been recognised by government, where consumer interests have, what I call, become obfuscated or clouded, and in fact, sometimes relegated to not even an afterthought. And given a number of high-profile data breaches here and overseas, we have seen the regulator and government step in to look at what's going on and effectively regulate the Wild West. And we're now in a significant era of regulator intervention and reform. We're 2 years into it, effectively. Anyone who has data or personal information as their centre of gravity of their business is going to be affected. And I would like to see any business today that doesn't use some form of data or personal information as the core of what they do. And so that's where it is. So thanks, Sam. Slide. So by way of overview for the next 45 minutes, so Sam, how long do I have?
45, but how long do you need? You know.
Oh, look, I'll just see if I can finish before 1. How's that sound?
Okay.
And also, are we taking questions as we go or at the end? How do you prefer to roll?
Look, it's a small audience, so let's go as we go. Just jump in. It's intimate mode. If they have any questions, yeah, just speak up.
Well, sure. What I'll do is I'll prompt for questions at certain points so people can ask as we progress, maybe.
Yep.
So just by way of overview, we'll relook at where the current regulator inquiries, investigations, and reports are, and things have moved on over the last couple of years, and there's quite a lot of them, and we'll quickly just overview that. We'll look at what we really mean by privacy and personal data. What is it? That's a really important question now and tomorrow. We'll look at the privacy reform, what has been telegraphed by government as a result of the various reports and reforms, what's been telegraphed, but of course we don't have the legislative packages before us yet, but where that may go. And then bets for the future is really my own prediction of what's going to happen, and that's a little bit sort of obvious that there's going to be reform, but what you as an agency can do to get ready for reform in the future. So that's where we're at. Slide, thank you. So current regulator inquiries, investigations and reports, obviously that's where we're at now. Next slide. So the digital platforms inquiry final report, just next slide there, Sam, that's right, if you just go down to the 4 points, pausing there, thank you. That report came out over 2 years ago now. It was 600 pages and effectively confirmed that all the laws that we have aren't keeping pace with technology and commercial practice. It was the ACCC, the Australian Competition and Consumer Commission, that was asked by government to undertake this report. Interestingly, it was not the Office of the Information Commissioner, which has the remit to protect privacy. It was done by the ACCC, which is to protect consumers and competition. So it was an interesting selection of who got the gig to do this. As you can see there, that report had a very strong focus on consumers' privacy and data and standards of consent and transparency. Ramifications, there are huge ramifications as a result of this report, as we will now see, for businesses involved in data processing, handling and dealing as core to their business model. On the 12th of December 2019, the government responded. It took them 6 months, but they responded with a roadmap to policy and reform. And so in the last 2 years since the government responded, it's been very, very busy. So next point, please. And then just the following points there. Thanks, Sam. One more. Just pausing there. So we have the Digital Platform Services Inquiry, and that's going from 2020 to 25. So 5 years of inquiry that's happening. It's an inquiry into the markets for the supply of digital platforms. It covers everyone that's involved in digital, from internet search engines, social media, online private messaging, content aggregation platform, media referral services, and electronic marketplace. It's a very broad inquiry. It covers digital advertising services, so really targeting your members, Sam, supplied by digital platform service providers and data practices of digital platform service providers and data brokers. So to a degree, that inquiry captures what media agencies do. There's been a number of interim reports that have now come out. There's been recently, at the end of last year, there was, on the 28th of October, there was a third interim report. So there's been 2 interim reports that mainly targeted what Google and Facebook were doing. They're the main focus of all of this, by the way. But they released a third report saying choice screens and how choice screens should be something that is used. And we'll talk about that a little bit later in terms of gaining consent from consumers. There's going to be further reports in this year, in 24, and a final report in 25. And then at the end of that time, and actually during that time, we will see legislative reform. So that's the very big piece, the Digital Platform Services Inquiry. Next point then, what we had back in March last year, that's right, that's all there is for the moment there, Sam. We had the Digital Advertising Services Inquiry, which was effectively an examination into the supply chain around the delivery of digital advertising, from the advertiser who wants their product right through to Google, who might present the ad, or Facebook, or whoever. And the final report, called the AdTech report, was issued on the 28th of September last year. And effectively that very much looked at competition aspects of the tech stack and the ad chain supply, I suppose, service chain. and that directly related to the communications industry. And they talked about advertising agencies as being part of what they commented on, but that includes media agencies and anyone in the world in the comms, professional comms world. Interestingly, and again, I could sit here and talk 2 hours about that report. You can find it; it's pretty easy to find. It's a long report, but media agencies did pretty well out of that. Generally speaking, it was found that media agencies had good, transparent processes around contracting with advertisers, and that they were generally complying as a good citizen in that chain of supply. The big problems still reside with the opaqueness of the ultimate provider of the channel, namely Google and Facebook. Continuing on, we're now also under some major reviews of the Privacy Act. So the first point there, Sam, is that the whole Act is being reviewed to ensure that the privacy law empowers consumers, protects their data and supports the economy. So there is a balancing act going on there, because if we make things too restrictive about what we can do with consumer data, then people can't do business, because everyone's doing business with data. We're going to talk about that in a significant way in a moment. And there's a concurrent review going on with a proposed online privacy bill. Now, as the blue call out there, or the blue point, is that there will be, as a result of all of this, there will be new laws and codes. The big piece, the big thing will be transparency and consumer protection, privacy and data as the focus. And I'd like you all to remember, it's about these 3 things. And these have come out of, I've cherry-picked these words that keep coming out of cases and reviews and submissions. It's about choice, consent and control for consumers. And that will be, the focus will shift to those 3 things. How that all happens and what you guys have got to do about it is the rest of this presentation to a degree, as best as I can forecast it. But those 3 things are what really, really matters. Are there any questions on where we're at the moment in terms of the investigations and reports that are impacting privacy? No? Okay. Probably clear as mud, but there's a lot going on, if I might say that. So thank you. Now the next slide, we're just going to have a look at where we are with the current laws. Where does it sit today? And it's interesting that things were rather sleepy before the Digital Platforms Inquiry in terms of the OAI, Office of the Information Commissioner, and the ACCC in things concerning privacy. It just was all very sleepy. They were looking at other things. But ever since the Digital Platforms Inquiry has happened, we have seen a resurgence of interest in using existing laws to play catch up with what's going on. And that's what we'll have a quick look at now. So currently, as most of you would know, we have the Privacy Act, and under that are 13 Australian privacy principles that govern the way that we should collect, use and disclose personal information. The current laws apply, and this will change significantly with the new laws, but currently it only applies to a business that has an annual turnover of 3 million, or if you trade or use PI as part of your business. So if data is your center of gravity and you're trading in it or you're using it as a commodity, then you will be caught, doesn't matter what turnover you have as a business. Now, just as a very, very, very simple update and refresher, the Australian privacy principles require a privacy policy that sets out certain things, and most of you would know that. The collection of the data and a core personal information must be necessary for legitimate business purposes. So just because you have a privacy policy doesn't mean you can collect information. It must be legitimate for your business purposes. And the second that business purpose no longer exists, you must get rid of that personal information. Separate to that, there must be a separate disclosure or collection statement under APP5 that provides upfront information to an individual about the collection and use and disclosure of PI. And that is one thing that most businesses don't get right. They have a privacy policy that is some sort of motherhood document, but they don't have a targeted collection notice at the point of collection that actually says what's happening about that information or that bucket of information that is being collected. And that is a real problem for a lot of businesses, and they're not doing it. They're still not doing it. It's been around since 14 and they're still not doing it. That's what's required now. Now, I just call out the direct marketing piece in the privacy law under the APPs. And APP 7 deals with direct marketing, and that's using personal information for direct marketing. And you may find it interesting to know that actually direct marketing is entirely prohibited under the privacy APPs. So they've taken the position that it's prohibited, but there are some exceptions. And so you can use it, but you have to come under an exception. The two main exceptions are in APP 7.2 that the individual would reasonably expect to receive marketing communications from an organisation and their personal information is used for that reason. And when would that be? Well, that's when your collection statement discloses that that would happen, or as part of a contract of onboarding a client, you tell them that you will be sending them information. So they would reasonably expect it. A client would reasonably expect to receive information from their bank about their banking products and services. Or under APP 7.3, you can, it's effectively your one chance to get your message to a consumer. If they wouldn't expect to receive anything from you, like you bought a list of data from or names and addresses from a broker, and you want to send an envelope to 50,000 people for a donation to guide dogs, you have one ability to send that if it's impracticable to obtain the consent initially, but then you must provide a method of opting out. You must provide an opt-out statement, and the individual must not have opted out before. So you get one bite at the cherry to send something under the privacy law currently for direct marketing. That may change with the new laws. Just remember though that from a digital point of view, you're still governed by the spam laws, which do not allow a one bite at the cherry scenario. You must have consent to send a commercial electronic message to consumers, and I'm talking about the good old email or SMS or MMS. I'm not talking about social media because that doesn't count. You must have consent to send an EDM, whether that be express or conferred consent. So this doesn't get you out of that. This is mainly for mail kind of situations and telephone where you're not on the do not call register. So that's currently where we sit with privacy. Is everyone okay with where we're at with that point? Does anyone have any questions? I know I'm moving through reasonably rapidly, but I think most of you will probably know what I've spoken about there. Well, what is data and what is personal information? And that's a pretty important concept now and into the future. So it may not surprise you to know that as far as we're concerned in the digital realm, data is, one definition is any information in digital form that can be transmitted or processed. That's what data is. And under the current privacy law, personal information is defined as information or an opinion about an identified individual, whether or reasonably identifiable individual, whether it's true or not, or the opinion is true or not, and whether it's recorded in a material form or not. That's the current definition of personal information under the privacy laws. And one area that's been very much overlooked over the last few years is, well, an identified individual of Stephen von Muenster at this email address, at this street address, with this mobile number as a standard name, rank and serial number, that's obviously an identified individual. That's personal information. But someone who is reasonably identifiable has really not had much airplay in the last few years, but that's meant to cover the situation where someone may not be identifiable from the face of the information, but could be identified through the combination of other data sets without having to do too much. There hasn't been much investigation of that. That's going to be tightened up in the future. So most people think that it's name, rank and serial number, and that's pretty much it. It's not exactly right. So of course, personal information is actually just a type of data. And whilst our definition is quite broad because of the reasons I've just mentioned, most of you would be familiar with the general data protection right in the EU, and California, for example, have very broad definitions. And what we're seeing now through these changes that are going to be coming is we're going to see, obviously, a move towards the GDPR California approach. And we're seeing a trend towards any data that relates to an individual being personal information, any data, even if it's anonymous or de-identified, because of artificial intelligence and data analytics technologies that are now available to combine with that anonymous information to identify someone. And if you have a look at the definitions of GDPR and California, they very much say that personal PII, they call it personally identifiable information, includes direct or indirect identification by reference to identifiers such as, forget about name, but more about identifications, just numbers, location datas, online identifiers, whatever that means, including types of data that enable you to mix and match and profile through physical, psychological, genetic, mental, economic, cultural, or social identities. And so you don't need to know the name, address, and rank and serial number of the person. You just need to be able to track their shadow, and you're caught by the GDPR. And same with California. And that's where we're going with our privacy definition of privacy laws. And we'll get into that a little bit further again. So there's the ability to say, oh, that's just anonymous data. We're okay because it doesn't identify anyone, and we can sell that anonymous data or we can use it. That's going to fall away. And that excuse will disappear in the future when the laws change. So any questions on that? I just thought it'd be helpful to look at what the other countries are doing. Good. All right, Sam. It's a very chatty audience today.
Mate, it's not you. Every time, everyone's normally pretty polite and quiet, and sometimes if there's questions, they'll come to us afterwards, and we can direct them to you. So
no worries. That's as long as people aren't falling asleep, that's good. So remember, we're still under the current laws today, and the current laws. There's been a resurgence in over the last 2 years of the use of current laws. They forgot they had them, and now they remember they've had them. And we're seeing prosecutions. And so the OAIC is the Office of the Australian Information Commissioner, used to be called the Privacy Commissioner. They regulate privacy. And they took proceedings against Facebook in March of 2020 in the federal court. And this is a current prosecution. And effectively, in that case, and you can have a bit of a read of that Facebook, through its collection of data, repeatedly interfered with the privacy, apparently of about 311,000 Australian Facebook users, and they were disclosing their personal information to an app, even if the person didn't download that app. And they didn't adequately inform these people that they were doing what they were doing. And it was interesting that if a friend installed the app, that information was disclosed of all their other friends as well. So there was a fair amount of data breach. I suspect it was a lot more than 311, but that's where they landed. So the personal information of all these people was exposed to the risk of disclosure, monetization, and use for political profiling. Next click through, Sam. Now, we don't have a judgment yet. It's still before the courts. But there's some pretty important lessons that are coming out of this case under the current privacy law. Consent needs to be obtained directly from the person involved. Just because my friend on Facebook does something doesn't mean I'm giving permission to Facebook to do something with my data. And that's a big problem. So that has to happen. Another big call out, and I'll make this point later or my closing points, but you've got to have really strong contracts with your providers and your third parties that you deal with to make sure that this sort of thing doesn't happen and that they're complying with the privacy laws. It's very hard to make Facebook and Google do the right thing, but I suspect after these cases, they will do what they can, plus the new laws that are coming in. So there's an allegation that Cambridge Analytica, and you might recall that the Cambridge Analytica fiasco was one of the catalysts for the digital platforms inquiry and the big data breach that was on a global basis. Again, the issue is the inability of users to exercise choice and control about how their personal information is disclosed. Interestingly, the OAIC is actually seeking a penalty for each individual act of unlawful disclosure, and the penalty could theoretically be as high as $500 billion under the current law. Whether it's actually that, who knows, but we don't even have a decision yet, but I suspect it'll be a pretty hefty fine at the end of the day. So that's what the Privacy Commissioner is doing with Facebook. Why did they do that with Facebook? Because before that time, the ACCC got into Google. So the next slide, please. So the ACCC, being the competition regulator and the consumer regulator, stole a march effectively on the Office of the Information Commissioner and got into privacy, protecting privacy or going after privacy breaches, but using the consumer law, not the privacy law. Section 18 of the Australian Consumer Law says organisations must not engage in misleading or deceptive conduct, or conduct that's likely to mislead or deceive. And that is the section that ACCC right now is using to bring those that are misusing personal information to heel through the misleading and deceptive conduct provisions. Very interesting. Now, a quick win they had was in August 2020. There was an organisation called Health Engine, and Health Engine was it may still be, I'm not sure if it's out there, I don't use it, but to assist people book medical appointments with their GPs. And they got a lot of GPs to sign up to this as a wonderful booking app, but it really was a data collection strategy to sell the data to insurance companies. And there was an allegation which didn't go anywhere, selling it to personal injuries lawyers as well, so that people could be contacted for ambulance chasing purposes in personal injuries law. So they were found liable for Australian consumer law breach, and they were issued a $2.9 million fine just recently, last year, and that's when the proceedings commenced in August 2020. Now, the takeaway from that is hidden disclosures are not sufficient if they're buried in the privacy policy. And what happened was there was a couple of oblique references in the privacy policy that said your information and personal information may be collected, used and disclosed and given to third parties who are our partners. But what the ACCC and what this court case says is no. Right up front, at the point of collection, they needed to say your information will be provided to insurance companies and lawyers. That's what they needed to do, not bury it in a privacy policy way down and some 5 click-throughs through. And we'll get into that in a moment, but that's where this is all going. On the 19th of October 2019, we've got proceedings against Google that were commenced and a second case against Google on the 27th of July 2020. The first case on 19 October 19 has been decided, but no penalty has yet been given out that I can see. But Google, it was alleged that and found by the court that there was misleading and deceptive conduct by Google via the phone screen about the sensitive and valuable location data it collects, keeps, uses and discloses. And people didn't know that Google was doing this in a proper way through their screen on their phone. And the takeaway that was informed choice is the key to not being misleading. We're going to look at that case in a little bit more detail in a moment, the next slide. But that's, sorry, Sam, just back one. That will be on the next slide. But the second case on the 27th of July is a second case against Google, which is more serious again, where they're alleging there was misleading conduct in obtaining consent to expand the scope of the personal information that Google could collect and combine about someone's internet activity for the purposes that include targeted advertising. And effectively what they're saying is that they bamboozled consumers so much with such significantly long terms and conditions that no ordinary or reasonable consumer would ever read them or understand what they were reading. And it's about a failure to obtain explicit informed consent to doing that. So you can all see a common theme of those 3 C's that I postulated at the beginning. Next slide, thanks, Sam. So on the first case, the 2019 case, that was decided, and the citation is from last year. And as I said, on this case, it was argued that that Android mobile devices users were misled due to the web and app activity and the location history screens, because they were found liable that during the setup and after setup, they turned off the features that allegedly gave privacy to people. So the point was that I think there was 2 components or 2 places in the Android phone that you had to turn off to get the privacy, and people only thought they needed 1. And you've probably found that with Apple as well. You kind of got to turn it off in 3 or 4 places, and if you're lucky, you get some privacy. And that was the problem here. Next point. The main issue is about informed choice, about how data is handled, and rather than the default setting being present whereby certain data can be collected. So informed choice, it makes it clear to businesses that representations made in their privacy policies and privacy settings can lead to liability. So just because it's in a privacy policy, just because your privacy settings have it, that in and of themselves could lead to liability because it's not clear enough. And that's what happened to Google here. Next point. So we've got the ACCC focusing more on the disclosures and how it is collected, used, and disclosed, which is coming out of this case. Businesses should now consider how terms and conditions, particularly around data, are presented and likely to be understood, because if they can't be understood, it'll be misleading. And it's not hard to fall foul of Section 18 of the Australian Consumer Law. Misleading or deceptive conduct is not a high bar. You don't have to intend to do it. It's just something that can just happen. And it's all about the class of consumer. And we don't have a particular type of consumer that uses phones, Android or Apple phones. It is the young, the old, the gullible, the astute, the educated, the uneducated, the whole class. And all you've got to do is show that some child who doesn't know what they're doing, if they would be misled, you're gone. And it doesn't even have to be an actual act. So that's why that was pretty obvious that Google was going to get down for this. Next slide, next point. So where we're at, and this is a big takeout here, the courts are deciding that consumers are time poor, unlikely to effectively engage with the information in a layered, technical manner that requires all these click-throughs. No one's going to do that. Businesses must consider what information must be presented in an easily accessible way and understood. And this is the choice screen thing where it's going to get to, supported by comprehensive collection statements, which was APP5 what I spoke about before. Now, Apple have done a bit of this about other apps. So when you open an app on Apple, often the question pops up now. This app wants to be able to do these things. Is that okay? That is Apple protecting its backside on its platform and giving the consumer a choice about whether or not that app can connect to your photos or your phone or your camera or whatever. But this is going to take it to another level. Okay, so next slide, thanks. And just the point about Health Engine. Health Engine buried everything in its terms and conditions, and the very act of burying it was part of the reason why it was misleading and deceptive. So any questions on that previous part? Did anyone have any questions on that? Am I going too fast or?
Janet might have a question in the chat feature.
Can I see the chat? You want to read it out to me, Sam?
Yeah, let me see if I can pull it. Is it legitimate for a client to use the first-party data, their members, as a sample for a U&A and media consumption research? Please also clarify the legitimacy of zero privacy data. Stephen, thank you. Does that make sense?
Well, Again, looking into the future, I would have thought that if you want to use data for any purpose, the consumer or the person whose data it is needs to have consented expressly to that use. So if you want to use it for that purpose, which may be secondary to the original purpose of collection, then I would have thought that you'd need consent for that. But without knowing about the data set or the collection channel or the disclosures at collection, it's very hard for me to answer that, but it's about consent and choice and disclosure. Yeah. It's a technical question, so maybe it's better when I take off offline with Janet if she wants to talk about that. But again, these are just principles that I'm giving you, but it's going to be harder to do what you want to do. Cool. All right. Well, look, reform, we're now moving into what reform is on the way, and we're making good time. I apologise that these slides are a little bit data dense, but I've done that deliberately so that the takeaway slides you guys can have a read about. But I'm now talking about those elements of the privacy law reform that's underway, which I mentioned in my initial slide about all the different inquiries that are underway. And on the 12th of December, the Attorney General announced that there will be a review of the Privacy Act, and that's no surprise. Now, there's a few key takeaways from the current review. We don't have the legislative package yet. We don't know what's going to go before Parliament, but Sam, next point, I've listed a few items there for you about what to expect. Now, the key things about what you can expect, I've really highlighted in yellow. And again, there will be, the new privacy law will have a much greater emphasis on transparency, protection of individuals. So the individual will become the focus. Remember at the beginning, I said the individual's rights and of their own personal information has become obfuscated. That's going to come out, and we're going to see individuals being the focus, obtaining express consent for the use of personal information. And the ability to step around and get exceptions is going to become diminished. Like perhaps APP 7.3 that at the moment allows you to use personal information even though you don't have permission. You can read those other ones, but ultimately fairness, stronger accountabilities, that sort of thing will come in. Stricter requirements for when and how consent is obtained. An updated definition of personal information to include technical data, online identifiers, and additional protections in relation to what people describe as de-identified information. That's coming, and that's what I told you about before. So this change, just simply changing the definition of what is personal information will in and of itself be the game changer in terms of that, because things that you thought wasn't PII is going to become PII. And then it all has to fall into your regime for what's there. So again, that's going to, and we'll summarise in a moment, but that's going to require you as agencies and your clients and your service providers to have a look at what they do in a very hard way. And we'll look at that in a detailed way in a moment. So next slide there. So in addition to the amendments to the privacy law, there's a new online privacy bill that is going up before Parliament. And this is another piece of law on top of the privacy law. And it'll introduce a binding online privacy code for social media and other platforms. Now you can imagine once this comes in and the new laws that come in, how the platform, like the phones, the people that manufacture the phones, the people that manufacture the Apple phone, and then of course, Facebook, Google, that will become they will be significantly impacted by that, and they're going to change the way they do business. And that's obviously going to percolate through the supply chain, right through to what advertisers can or can't do. So it'll be very interesting as to what happens. But what to expect against, we don't know the legislative package, but some of the big key points there, there's going to be a legal required change about how organisations approach protection. It's going to be a consumer-first approach. Social media companies, data brokerage companies, online platforms will be subject to more prescriptive obligations, and again, consumer transparency and consent. There'll be the rights for individuals to say, you need to stop using my personal information. And then your data, your consent verification requirements in relation to children and vulnerable groups will be massively increased. So children will be greatly protected. Another point, the new code will set out a number of things under the privacy principles. And if you just flick through them, Paul, yep, that's them there. Thanks, Sam. How the privacy policies need to be changed to be clearer and easier to understand, how consent must be voluntarily obtained, unambiguous, specific and current, and the collection notice that I've spoken about, the ones that a lot of organisations don't do, must be clear, understandable, current and provided in a timely manner. So that's what we're going to see with these changes with the online privacy bill. But again, we don't have a legislative package there, but it will impact agencies in a significant way, as well as part of that chain of supply from brand to media. Okay, so the future, this is fortunately for everybody, the last slide. What do I think about the future? Well, of course, the impact, if you just punch down the 4 points there, Sam, that'll do. Really, everything that's happening at the moment over the last, well, since the Digital Platform Inquiry report was released, right through to everything that's currently happening, prosecutorial vectors and the cases that you're seeing, anyone that has business with data and personal information as a centre of gravity is going to be impacted. I've made a point there that programmatic services, particularly for agencies that are involved in programmatic or other forms of data analysis or using clients' data to provide services back to the client, will be impacted. Data-driven businesses, whether it be loyalty schemes or sale of segmented data for targeted advertising, list brokers, whatever, they will be significantly impacted. So my big bets, so Sam, you just pop down the last few points just on the left-hand side of the slide. These should be pretty obvious, but my big bets, right now we have a consumer data right that's already in play. It has started with the banking sector. That's the ability of consumers to transport their data from one organisation to another without having to redo everything. So one banking company has to transfer all the consumer data of Stephen von Muenster to another bank and then get rid of it in their databases and hand it over. So that's a consumer data right so that you and I as consumers have better control over what people can do with our data in certain industry sectors, and it started with banking. We know the media bargaining code for tech giants has commenced. Well, that was just a thing that came out of the Digital Platforms Inquiry that's already happened. We're going to have regulation coming in of the ad tech industry, advertising and media agency services, more to do with what the transparency around what Google and Facebook do, but it will influence and affect what media agencies and advertising agencies can do. We're going to see GDPR-aligned amendments and possibly California data privacy-aligned amendments to the Privacy Act and increased penalties. And I reckon we could even go further than a GDPR. I reckon there could even be an overreach. We just don't know. We're going to see the Office of the Information Commissioner's Privacy Code for Digital Platforms, that is an enforceable code, coming in. We're going to see a broader definition of personal information. So that is going to include technical location data, IP addresses, cookie tracking, everything. And the reliance on anonymised data will be reduced and regulated. So that is, in and of itself, is a game changer. We're going to have stricter notice and consent requirements for data privacy policies and collection statement upgrades. And there's going to be a new right of action for interference with privacy and cyber harm. That's going to allow individual people to sue organisations personally for misuse of their personal information. And that's going to see and keep many lawyers putting their kids through private schools for many years, which is a good thing, I suppose. The next part then, and the final point is, who will have the commercial advantage now in this new world that I say and I think will be coming? Well, businesses obviously will be required to implement technical, legal and operational uplifts and changes to become compliant. And it's those businesses that are able to embrace the change that will have an advantage. And the point's really that you just could start thinking about as part of your business, about those that you deal with. Obviously, Google and Facebook will look after themselves because they're going to have codes targeted at them. But we're talking about a consumer rights and respect focus, and that's where it's going to go to, and it's going to need to do that. You need to have technological ability and agility. Transparency and compliance need to be part of your business model. Next few points, Sam. You need to be able to be auditable. You need to be able to show that the data that you have was collected with the consents required for the use that you're using it. And you're going to have to be able to, third party is going to be able to come in and go, show us that Stephen von Muenster gave you permission to use his data for that survey. Oh, well, here was what we gave him. This is what he did. He agreed. Tick box, check. You're going to have very strong contacts with your supply chain, because it is those people that could get you into trouble if you do not have strong contracts to make sure they're doing the right thing. As an agency, you might be doing the right thing, but what happens if your third-party suppliers aren't doing the right thing? And what does that mean for you? You could be part of the chain that is aiding and abetting a breach of the privacy laws or the consumer laws, and you will be just as liable as your suppliers. You can't just sort of say, oh, they did it. Won't work. Years and years ago, when I was involved with cases involving the Australian Communications and Media Authority, when the Spam Act first came into place, and I was involved in a large case with the sale of banking data. A big bank sold its SMS information, like its mobile phone data, to a media agency. And the media agency took that data and then blasted out a very, very large SMS blast to promote a drinks company. And everybody in the supply chain was prosecuted by the ACMA. The media agency, the creative agency, the bank, the brand, and everyone that was involved. And they all had significant fines because they were all seen part of supply. We're just going to see that here. And that was 15 years ago. I'm going to see that. We're going to see that come up. So you don't want to be that agency that's part of that chain of pain that might come up. Data hygiene, very transparent contracts with consumers. That's more for your clients. They need to be very fair and transparent with their consumers about what they're doing, not just in terms of privacy and data, but also in terms of the basic terms and conditions of buying their products and services. Because believe it or not, the Digital Platforms Inquiry also touched upon standard terms and conditions with consumers, and they're not being transparent enough as well. So that's going to be something important. Data hygiene in terms of full disclosure and express unbundled consent via active opt-ins. Modern privacy policies, simple to understand with no bundling of consents, i.e. individual consents are needed, and you actually follow your own privacy policy. There's a lot of privacy policies there that businesses just don't follow. Choice screens supported by comprehensive collection statements. And the last one there is, Sam, is the big one that I want you to think about is what is the great unknown that I call the great unknown. What's going to happen to current databases when all this new law comes in? Will they grandfather it and say you can use it, but you now need to comply with new data laws going forward for anyone new? Or are they going to say everything you've got is contaminated and you can't use it, you've got to start again? I don't know. There's nothing I can find about that, but that was a big issue in 2014 when the new privacy laws came in then, and we dealt with it. It just never became a big issue, but it was something that was of concern to a number of businesses. But I think this is the great unknown for me. What happens to existing databases, which have grown quite large since 2014? And the final point, Sam, as I said, new laws and codes coming, transparency, consumer protection, privacy and data is the focus. And it'll all be about choice, consent and control that you need to afford to consumers. And Sam, that's the overview.
Guys, thank you so much. Thank you, Stephen. Is there any questions anyone wants to yell at whilst we have him here and on that, or any other topics? Or if not, we can connect to you afterwards.
Sam, would you like me to? Gary's waving goodbye. Would you like me to send you the PDF so that you can share that with the group?
Yeah, that'll be awesome. Please do that. I'll share that around the next newsletter. Gary's got a question. I think he's just raised his hand.
That was not a goodbye. That was
not a goodbye. It could have been a high five, but he's raised his hand.
Yeah, just a quick question. Well, I guess firstly, thank you very much for this. It's really, really interesting. But what's your estimate in terms of the time frame for these changes to the Privacy Act and the other laws that you were talking about, as in when will they become actual law?
Well, look, I think the platforms inquiry ends, the major inquiry ends in 2025. I suspect this year's an election year. I'm not quite sure what will happen before the election. I suspect we'll start seeing the judge-made law come in with the cases being decided in 2022, which will already have a significant chilling effect on what the big platforms do. And I'll be looking at new laws in 23, 24 and 25, but that's as good as I can give it to you. I'm sorry.
Okay, thanks.
Any other questions, guys? All right. Look, thank you, Stephen, again, and thank you, members, for tuning in. We will circulate this in the next couple of days, and obviously we've got a video of it as well that will be housed in our YouTube channel, so look for it there. Thank you so much, guys. Enjoy the rest of the day. Talk to you soon. Thank you, Stephen.
All right, thank you. Bye.